Once that happens, within 5 days of the board getting the report and accepting the reported incidents via resolution, the parents of both the victim and the bully are notified of the results of the investigation. The parents must be advised of the nature of the incident in the investigation and whether the district found evidence of hit and whether there was any remedial action. What does not happen, and it is very clear, is that the parents are not entitled to review the hit investigation report. They're simply informed as to whether discipline or remedial action was taken, and they can't be advised as to what discipline or remedial action was taken against anybody else other than their child. Obvious reasons why that is, and that's primarily the privacy rights of the children that are involved. It may seem counterintuitive that the victim of a HIV incident would want to know that the remedial actions were taken against their child harasser, but the law does not permit you to violate that other student's privacy rights. After the parents have been provided with the information, that's when a parent can request that the board give or grant a hearing to that parent. The hearing has to be conducted within 10 days of the request. And as with every other student matter, it's a confidential hearing and executive session. There are no specific parameters of what that hearing looks like. There's no regulation that governs the process that is owed to a student that is requesting a hearing. That could be a request from the bully that the remedial actions are too severe, or from the alleged victim as the remedial actions were not severe enough. So you have appeals from both sides to the Board of Education. At that point in time is when the board sits in judgment, if you will, of what the recommendation was, what the facts of giving rise to the hit incident, whether the finding is correct or not correct, in terms of whether there was a hit incident, whether it satisfies the legal parameters of was this a harassment and condition bullying incident as defined by statute, or was it not? Were the remedial actions enough? Were they not? And go from there. The burden is on the individual challenging the action.
Can you just clarify one, please?
One thing, the so-called victim or the alleged victims.
The alleged victim's family doesn't have access to information.
Can you use the other microphone?
The alleged victim's family doesn't have access to what intervention was taken with the alleged harasser. But the victim's parents can come forward and request a board hearing based, is it only the harassers?
When they receive the notice that your child was the victim, pretending it was an upheld HIV incident. Your son or daughter was the victim of an HIV incident, remedial action was taken, the parents can request a hearing and say, well, I want to see some level of proofs of what occurred. It would be at that point that a redacted version of the investigation would most likely be given so that they can see what happened, but they would not be given any identifying names, addresses, and so forth. They would just be given factually what occurred and what was the recommended course of action.
So basically, they push hard enough, they can find out what happened.
Yes. The burden is on the person challenging it, whether it's the alleged victim thinking that the actions were not significant enough, or the alleged bully saying that it should either not be founded or the remedial actions are too severe. It's fairly significant burden to show that the recommended actions are not appropriate. The standard is whether the actions that were recommended are arbitrary, capricious, or unreasonable. The parents who file an appeal can bring it to the Commissioner of Education on an appeal through the Department of Education, which goes to the Office of Administrative Law for a fact-finding hearing, and that has to be done within 90 days of the final board decision after the hearing. Yes.
Yes. Would there or should there be a time earlier than the 2 days that the superintendent gets the report that he's aware that there was an incident?
What the law says, what the law says. The timeline is fairly straightforward. Whether the board or the superintendent can report out earlier or the superintendent can report out earlier is to the superintendent. If it's a belief that, in a shut circumstance, I guess, that it was a clear-cut violation.
You would not probably even know about it until it was reported, is my point.
Oh,
It
yeah.
could be something, it's up to the principal I'm thinking, to determine whether this is something that the superintendent should know so he's not.
Correct. There's lots of instances of that. Anytime that there's misconduct on any campus, whether it is an elementary school or high school, principals need to use a level of common sense and discretion as to, whether they're going to inform the superintendent that there was an incident. It doesn't need to be a hidden incident. A fight involving 5 kids in the cafeteria, a principal, I guess, would be well served to notify his superintendent that an incident occurred before the parents start calling the superintendent, creating a hubbub. But in terms of a hid issue, you still need to conduct the investigation. Not every incident is a hid incident. It's just not. You still need to meet the standard in order for it to be considered hid. Doesn't mean that there wasn't misconduct. Doesn't mean that it's not a violation of the code of conduct by the students. It doesn't mean that there would be no consequence for the misconduct. It just means it's not a hid issue. Just like every incident that occurs within the school is not a violence and vandalism reportable event. There have to be certain criteria in order to reach that level of reporting. So there's lots of cases out there, what is hid and what's not hid. We could go through it and spend lots and lots of time doing it. These are most of the recent cases that I was able to find that show what hid is and what it's not on an appeal level, where a court with a commissioner ruled on it. It's pretty easy. All the standard stuff like calling somebody, a racially derogatory term, or something that is insensitive to their sexual orientation. Those are no-brainers. Those are hid incidents. You don't call someone a racially derogatory term unless they're a member of that racial classification. It wouldn't happen. You wouldn't call someone, a derogatory term in terms of their gender identification unless there was a reason, that is coming out. And the investigation will show that very, very quickly. So some of the cases, saying that someone dresses like a girl or calling a student gay, it's a fairly straightforward, no-brainer kind of circumstance. Where the appeals come in is what is the consequence for the action. Many times it is that the penalty was too severe, or that it wasn't severe enough. There's instances where folks are looking to get damages awarded for $50,000. That's just not available. That's part of this process. The cases are very straightforward. I certainly welcome you to take a look at them. The first one is dealing with calling someone gay, seemingly a no-brainer. The second one deals with, right out of 10 of 5, dealing with a single incident occurring where someone is accused of having head lice. It was reported as part of the harasser's discipline file, and they wanted, the parents demanded that the file be expunged, a written apology, all kinds of stuff. $50,000 for emotional distress. It just wasn't going to happen. The commissioner agreed. The board acted consistent with the requirements of the law, and even though the alleged harasser was simply saying, well, I only told the truth, the person did have head lice, it just wasn't an appropriate comment to make. So the action was just greater sensitivity to other people, and the harasser went way over the top. In Ridgewood, the case came out where someone was calling a student fat ass or fat, and the board found that that incident constituted a hit and imposed a 2-day detention. The ALJ found that the conduct fell squarely within the HIT guidelines. That it was the student's appearance and body type that was being identified as the distinguishing characteristic, and that the district actions were appropriate, and so they sustained the 2-day suspension. Whether it should have been a 5-day suspension or a 3-day suspension, the commissioner and an ALJ are going to be reluctant to put themselves into the shoes of the Board of Education and say, well, if it were me, I would have done X or I would have done Y. The board's decision is owed a level of deference of being the body responsible for making that determination. There are certain other incidents, again, anything gender identifying or race identifying is going to be a no-brainer. The cases that aren't hid are probably more interesting. There was an incident in Freehold where two students were going at swim meets and at parties and online, and the board found that it was not a HIB-related incident. There was no identifying characteristic that these two kids were engaged in that was going to be protected by HIB. It didn't mean that it wasn't actionable. It didn't mean that the board would do nothing. It just, the commissioner found that the board demonstrated that it took the proper action. It didn't arise to a HIB violation, but it was more of just a mutual disagreement between students that may have violated the code of conduct, but it was not a HIB-based incident. It goes on, a couple more pages with other cases, but the lessons learned here are really two. The first lesson is you need to have strict compliance with the timelines. Very, very important. It's important for the administration to do correctly by the timelines. It's important for the board to comply with the timelines. And the second lesson is that these things are a very fact-sensitive determination. You go through hypotheticals all day long, and you may be right and you may be wrong. But it's probably safer to stick with the letter of the law than it is to start insinuating yourselves into a circumstance whereby you're putting your own sensibilities into, well, that's just not right, so it has to be, you're getting bullied because it's just not the right thing for one student to do to another. You really need to stick to what the definition of HIB is and then be fairly consistent with your analysis in applying those factors. Question?
In regards to if you're a board member, it says that you have to report to the principal. If you report to the superintendent, does that count? Or you have to get in touch with the principal?
You should be going right to the building principal, but if you put it to the superintendent, then it would be incumbent on the superintendent to report it. But the person witnessing it should be reporting it to the school principal. Or getting credible information that it occurred. So if you get information that something occurred, and send an email to the school principal or you call them, you certainly should reach out to the superintendent as well, because of the change.
If there's a question that the principal is doing something that's, biased to a student, how do you approach that?
Then it goes to the district coordinator or the superintendent. And the whole process will follow through. Just without it. Maybe I should back up. HIB applies to student on student and adult to student. I guess theoretically student to adult, although that's very rare. It does not count adult to adult. No HIB for two adults. There's a whole other set of laws and circumstances.